second question which is usually asked is, what really is my right as a citizen to prevent unlawful stop and search? Today we would like to look at traffic stop and searches. What really is my right? What really is the protection of the law? And what really, on both sides, what is the right of the policeman who can exercise that power to stop and search? And what really is my right as a citizen from ensuring that that stop and search is not exercised in an unlawful manner? Now, before we even get to examine the motor traffic and vehicle legislation, let us look from our modeled legislation or the supreme law that we consider, and that is the Constitution of the Cooperative Republic of Ghana. Articles 143(1) clearly says, except with his own consent, no person shall be subjected to the search of his person or his property or the entry by others on his premises. Now, clearly, constitutionally, you have a right not to be subjected to search. Now, that is constitutionally. You may want to interrogate that further and ask yourself, is that an absolute right, or is that a right which can be suspended? I will say that it is not an absolute right, meaning that there are circumstances in which the authorities, in this case the police, can exercise a lawful power in relation to subjecting you to a search. Now, we must note that there is a line of case laws, including the Attorney General in Williams, which was a 1997 case at 51 West Indian Report at 264, which talks about a person has a constitutional right to be free from illegal entry and from any illegal search, but that this search is not, or this right is not an absolute right. Then let's go to the police's powers. The police's power to stop and search comes under the Police Act, Chapter 1601. And you may want to consider Section 18, which clearly gives the police the power to stop, search, and detain vehicles or persons in certain circumstances. It is important for us to recognize that that can only be exercised in certain circumstances. So that, let us examine those certain circumstances. A member of the force, a policeman, can stop and search and detain a vehicle or a person when they are of the belief, which is an objective one, as we will see later, that the person is a suspect. And that person is a suspect because that person has stolen or has an unlawfully or has an item in their vehicle that is unlawful. Now, that person may be subjected to have been committed or have committed any indictable offense, and it's found that they have committed an indictable offense. But the watch term that I want to be able to get across to you is that there must be what is called reasonable suspicion for the police to exercise that power. Meaning, if the police is stopping your vehicle because the police is of the belief that you have stolen something or that you have an unlawful item in your vehicle, then there must be reasonable suspicion that that is so. It can't be that the police is just stopping vehicles randomly, and they're searching for certain items. Then the stopping of that exercise in itself of the police stopping vehicles without any reasonable suspicion that the person that they're stopping has committed an offense or is about to commit an offense, then that exercise of power will be unlawful. Now, let's look further at the interpretation of the power. The interpretations of the power will be clear. Under Section 18 of the Police's Act, to stop and search, there must be, I will consider that there must be three circumstances, which I will, of course, respectfully identify to you. One, there shall be a reason that the person is a suspect, meaning that that person has stolen an item or that they have an unlawfully obtained an item which they are in possession of. That is one circumstance that the police can stop. Two, that the person is suspected to have committed an indictable offense and is so found that the person has committed an indictable offense. And three, that there is reasonable suspicion that the person has been acting or has acted in such a way that it is founded that the person has committed an unlawful offense. Now, the second one, which I believe is important for us to interrogate further, what really is indictable offenses? Now, we have in our criminal law in Guyana certain regulations, and of course, it separates what an indictable offense is and what a summary offense is. The distinction is really made, and it became a lot more clearer if one looks at Dina Sitahal's book, The Commonwealth, Caribbean Criminal Practice and Procedure, 4th edition, chapter 1, and page 76. The distinction is really made in terms of the penalty, so that an indictable offense would be those offenses in which the penalty would be 12 months and over. That will be a most serious offense. A summary offense will be those offenses, of course, which carries a less term than that of an indictable offense. So that it is important for us to make that distinction, because the police will have, under the law, the police will have, of course, no justifiable reason for stopping and searching a vehicle if the offense which is alleged to have occurred is a summary offense, meaning that it's not an indictable offense. Then it means that that exercise of the police at that stage will be unjustifiable and it would be not covered under the law. If the police want to ensure that their search of a vehicle is covered under the law, then the person must have been suspected of that the person had committed an offense which is indictable. Now, let's go further to interrogate this whole issue of what is reasonable suspicion. We are not creating new boundaries here or new context in the law, because, of course, that whole issue of what is reasonable suspicion has been, of course, identified and explained by retired Justice William Ramlal in our own local case of Navindra Singh and the Attorney General, which happened just a few years ago. Now, the ruling and the reasoning, the legal reasoning of Justice retired William Ramlal, I believe, is very instructive in this regard. In order for the police to say that there exists reasonable suspicion, then there must be an objective test, meaning it must be applied on an objective test, meaning in all the police must take all the circumstances into account, including they must be able to have the proper founded information which can base that reasonable suspicion. That case even went further on to say, and I believe the legal reasoning of retired Justice William Ramlal is very, very instructive again, because personal factors cannot be considered at this juncture. Meaning, if the police have information in terms of, let's say, the color of the skin, ethnicity, hairstyle, the manner the person is dressed, the type of vehicle that the person is driving, or that the person has committed an offense, or that the person has a previous conviction, or even stereotyping to say, like, this person is a known person to commit an offense because the person has been frequent before the courts. That will not be, those are personal factors, and that will not be enough to ground a reasonable suspicion so as to stop a vehicle and to search the vehicle. Now let's go further and look at our own traffic laws. Now, we would recognize that in Guyana, we have the Motor Vehicle and Road Traffic Act 5102. And more importantly, let's look at Section 23. Now, a person shall not drive a vehicle on the road unless the person has a license. Now, if that person, of course, does not have a license and drive the vehicle on the road, then that person is going to be guilty of an offense. Now, it's a very narrow, I believe, example that we need to draw here. Now, if one is driving a vehicle on the road without a license, that person, under the laws, has committed an offense or is committing an offense. Does it give the right to the police to stop and search that vehicle? The answer again will be no. Because how would the police stop a person driving a vehicle without a license if that person there is not reasonable suspicion that that person has committed an offense? It means that the police must have that information first. Clearly, I am advocating here that the police cannot go on an expedition in which there is stopping and searching of vehicles, and then there is searching of documentations, and then they discover that a person does not have a license. Then the stop in itself, the search in itself, will be one that is unlawful. So, in a nutshell, I'm clearly stating that if the police want to be covered under the law, then there must be reasonable suspicion, which when applied under an objective test, can be that the person has either committed an offense or is about to commit an offense. So I'm clearly stating, if while driving, a person, let's say, drove dangerously, ran through a traffic light, drove carelessly, had persons running off the road, and it is in clear view of the police, then the police will have coverage under the law to drive behind that person and stop that vehicle. Of course, because the person had committed an offense. Outside of that, and if you want to examine further, in clearer local understanding, would the police have coverage if they decide that they are going to do roadblocks? And then sometimes we find where there is this road safety week where the police have numerous campaigns going on and so on. Even in those circumstances, the law is very clear that in order for a person to be subjected to a search and for that right, constitutional right, to be suspended, then the person must have committed an offense or is about to commit an offense, and that the police has reasonable suspicion that the person has committed an offense or is about to commit an offense. And that is under which the bracket the person, of course, can be charged and can be placed before the court. Outside of that, then there will be no protection for the police if they just, without justifiable reason, stop and search vehicles under the pretext that they have a traffic campaign going on. I thank you. Audio Jungle.